disagrees because this change directive is going to cost more money. Well, in that case, the disagreement becomes a claim under the contract. The contractor still must honor the contract and execute the directive. However, disagreements in the directive become claims, which must be filed within 21 days of the occurrence in the AIA standard documents. So that's the distinction between orders and directives. And further, if we had a change directive in which all three parties signed the change directive, it probably means that the contractor agrees with the directive anyway. Topic number 5, rules of interpretation, as well as 6 and 7, we're going to look at by looking further at those exhibits that you were looking at a moment ago. So look back to the exhibits A, B, and C that are part of this module, and let's take a look at 5, 6, and 7. Once contracts are in place, it may be that down the road someone is called upon to interpret the contract. And not all contracts are written clearly, and not all contracts contain necessary provisions. So sometimes it requires a judgment factor to determine who is right or wrong in a given situation. These general contract interpretation rules are what the authors of the Contractor's Manual have suggested are the general ways in which courts will interpret contracts. The first item is that there should be provision for harmony amongst the different provisions within a contract. The second is that the final document is going to be senior to any negotiations. So the written final word is going to be senior to anything else. There is a priority of documents. For example, in the contracting arrangement, as we've previously mentioned, if there is a dispute between a drawing and a detail, the detail will prevail. If there is a dispute between a detail and a specification, the specification will prevail. So the more specific the document, generally speaking, the higher the priority. Clear terms, item number 4 in a contractual relationship, are seen to be conclusive. The intention, number 5, of the parties is the thing that is to try to be ascertained. The whole idea is to have a contract with a clear intention so that parties interpreting the contract can clearly understand what was intended and in that way interpret the contract. Words, number 6, are given ordinary meanings unless they're specifically defined in another way. Number 7, sometimes industry standards can be the factor. Number 8, the goal is to interpret the contract as a whole. And number 9, sometimes if a contract is unclear and you can interpret it one way or another, it will tend to be interpreted against the party who wrote it. The third exhibit on general contract law deals with what happens when things go wrong. On the upper left, the issues begin with the contractor and non-performance by the contractor. What are the ways in which a contractor can non-perform? Well, he can abandon the job, and remember that in the licensing law, under the section that deals with financial mismanagement, abandonment is specifically defined. Defects in the work also constitute non-performance. Delays that are not reasonable or not due to specific circumstances beyond the contractor's control are also considered non-performance. And if the performance may have a certain level of quality, but it may be inconsistent with the contract. In other words, the contract calls for a refrigerator model A, and you provide a nice refrigerator model B. You've complied with providing a refrigerator, but you did not meet the standard that was set up in the contract. If the contractor does non-perform the contract, then there must be remedies that are allowed for the owner. And the two that are listed in the contractor's manual is, number 1, there usually is the opportunity to recover the actual cost to complete the project. In other words, the contractor has been removed from the project by the owner. And now the owner has to complete the project, and it may cost the owner more to complete the project than what the contract allowed for, and generally speaking, the owner is going to be able to recoup that. Also, the owner might be able to recoup possible damages from the relationship. A restaurant that doesn't open on time, that can cost the owner money. And if the contract is arranged a certain way, and if the contractor has really non-performed, then it's possible for the owner to come after the contractor for other losses. Well, assuming that there is a question about performance or not, some of the potential defenses that a contractor can raise to the issue of non-performance are, number one, the owner broke the contract first. Number two, the requirement was simply impossible. Or number three, there were unexpected site conditions. However, for number three to be used, the other items A, B, and C must be in place, all three of them. The unexpected site condition, A, must be significant. B, it must really affect the price. And C, it must not already be provided for in the contract. Well, a lot of times it's the owner's side that does not perform. And usually it's non-payment that is the most frequent way in which the owner might not perform. And the practical upshot of trying to overcome an owner's unwillingness to perform is that we're going to have to file a lawsuit. And this is a set aside from any liens. Remember, liens are special circumstances that allow you to encumber property. A lien can be placed for monies that have not been specifically paid. But we may have other claims against the owner by virtue of the non-performance. And to pursue these claims, we may have to file a lawsuit. There may also be remedies that allow for damages. And these damages are referred to as general and special. And the first issue that comes to mind, if we have to determine whether or not there will be additional damages, is whether or not the contract is substantially complete. Because if the contract is substantially complete, generally speaking, the owner is going to be able to recoup the cost to complete. But if the contract is not substantially complete, then some method has to be worked out to assess a reasonable value. And depending upon how this method is worked out to assess this reasonable value, it may be that some of the additional factors come into play that can modify the claim. For example, the price minus, meaning there that if you take the payments and take the cost to complete and subtract the payments, then that amount of money might be due the contractor. Sometimes, however, the contractor wants or expects a certain profit from the work, and the loss to the contractor is not only the value of materials in place, but also anticipated profit, and this can be sought as well. And thirdly, the issue will be the percentage of completion. And this will also tie into this value or this determination of a reasonable value. So you have damages that can be tacked on to an owner's non-performance, to claims for an owner's non-performance. Turn back in your module to page 2, Roman numeral 2, the Aia Documents, the American Institute of Architect documents. And the first thing that I think it's important that you're aware of is that while the state exam alludes to several of these documents, the main one being the 201, the American Institute of Architects actually publishes many, many documents about the various relationships that can occur in the contracting business. And this is a compendium of documents that the AIA has written. If you look at your outline, what you see are a number of issues that from time to time are asked about with respect to these documents. And what we're going to do in this presentation in a moment is go through some of the exhibits that were handed out that I believe will clarify a lot of these relationships. And your role, after you have a sense of how these relationships work, is to go back through the outline and mark the documents with the page references that are pointed out here. Now keep in mind, in the first module, you were shown an exhibit that talked about legalese, how to read a particular document. And the AIA documents are right up there. So you want to make sure that you read these documents with the idea of scanning first and then shifting gears and reading later. And when you're scanning, you're looking for the key ideas. You're looking for the subject, the verb, and the object as you go through this material. And so when you look at these sections and paragraphs, don't get garbled down in all the words. You're looking for the if-then, you're looking for the main idea, and then once you identify the main idea, then you can shift gears and more carefully look at the paragraph to make sure the information is what you need to answer a particular question. The most important thing to recognize about the 201 document are the various relationships of the players. And let me say before we turn you to an exhibit, that another feature of these documents from a reality point of view is that if you intend to contract under these documents, you want to make sure that you turn around and contract with all of your subs in the same type of document set. The AIA documents are designed to work as a set. If you didn't do that, you could wind up having an obligation to the owner, with the subcontractor not having a corresponding obligation to you, and you could wind up getting caught in a squeeze. The second thing is that although these documents are comprehensive, they're not absolute. And there may be provisions in these documents that you are not in favor of. So as you review documents with your professional advisor, and remember, we do advise you, because we live in a specialized age, to get help with these types of issues and ask an attorney, for example, about how you should contract, how you should structure your contracts. But as you go through these documents, recognize that you can change provisions of these documents if that suits you and if the other parties agree. So don't necessarily sign them just because they come in a nice, neat set. You want to make sure that these documents reflect your intentions as well as you go to contract. But understanding the relationships is paramount. So if you turn to your exhibit, the AIA documents attached to your module, we're going to go through this exhibit and try to explain the main ideas. Then you're going to need to go back through this information and mark your documents accordingly. If you have any questions, of course, ask your instructor. The next exhibit that you should take a look at is labeled AIA Documents. And what this exhibit is trying to do is to show you the main relationships and how these documents work with one another. Now keep in mind that your outline in your module is very specific and indicates page numbers for very specific issues within these documents. And it is important that you mark your documents with these specific issues. However, it's going to be much more or much easier to absorb these different issues if you have a pretty good idea of how these contracts work and some of the key issues within them. First of all, the main document that's looked at is the AIA 201 document. This is the granddaddy document. This establishes the basic relationship between the three principal players: the owner, the architect, and the contractor. Now, if you were not looking at this and you were asked how would you arrange the pecking order between the owner, contractor, and architect, it's very likely that you would place the owner at the top, you would place the architect right underneath him, and you would place the contractor beneath the two of them. But this is not the way that it is run. The architect has no contractual relationship with the contractor, so the contractor does not work for the architect. Any powers that the architect have are powers that are granted to the architect by the owner. And you'll notice in this diagram that the communication lines go from the owner to the architect. The communication lines do not go, or instruction lines do not go from the owner to the contractor. The contractor is expected to communicate with the architect. The architect will communicate the owner's wishes to the contractor. The dark lines of this relationship show the actual contractual relationships. The owner is under contract with the contractor. The owner is in a contract with the architect. Now, underneath each of these little boxes, I'm trying to show what the main principal responsibilities are for each of these players in this relationship. If we start with the owner first and look at these items 1 through 8, item number 1 says that any property issue is going to be the responsibility of the owner. For example, an easement is necessary for the property. That's the owner's responsibility. For example, water must be brought to the property line. Again, the owner. For example, the legal description of the property is incomplete or inaccurate. That's an owner's responsibility. For example, the filing of the notice of commencement. That's going to be an owner's responsibility. The providing of surveys in general will be the owner's responsibility unless otherwise said in the contract. And so in general, anything relating to the property is the owner's responsibility. As I said, number 2, the owner is responsible for an accurate legal description, and the contractor has the right to demand from the owner an accurate legal description. Furthermore, any contractor on the job has the right to request a legal description or an updated legal description from the owner. And the owner has the responsibility of updating the legal description if the owner has done anything to change the initial legal description. Otherwise, subcontractors would not be able to file notices to the owner. They wouldn't be able to find out the actual legal description of the property. Number 3 is builder's risk insurance. This is property insurance on the contract, and according to the AIA documents, the contractor will buy this insurance, but the owner is responsible to reimburse the contractor. Furthermore, the subcontractors also need to be covered by this type of insurance, and it's the owner's responsibility under the AIA contractors to do so. If a subcontractor felt that their work was not covered by the insurance because the owner did not buy enough of this insurance, the subcontractor would have the right to buy the additional insurance and charge it back to the project. The owner is supposed to have an ability to pay for the project, and the contractor has the right to request proof from the owner that they have the ability to pay for the project. The owner is expected, number 5, to make timely payments, 6, timely decisions, and 7, there is a unique situation where a claim is made to the builder's risk insurance policy. Now, by the way, any deductible would be paid by the owner because it's the owner's responsibility. But let's say the building burns down and there are claims made by the various contractors for monies received for the insurance. Well, the insurance money is going to go to the owner. And if the owner is in this situation, the owner's hat changes, because when the owner is distributing insurance money, the owner now has the role of making sure that the money is distributed fairly. And this is a unique and separate type of hat that the owner only wears in this situation. Otherwise, the owner, although bounded by the contract, is essentially in it for the owner's best interest. Number 8, the owner is expected to make fair payments. For example, if you're 50% done with the work, the owner is expected to pay for that 50%. It's not going to be sufficient for the owner to pay 10% and say that he is keeping in good faith with the contractor. So these items, 1 through 8, are generally the owner's responsibility. So what is the architect supposed to do? Well, the architect represents the owner, processes the paperwork, advises the owner, reviews the contractor document. Now, these are very important because the word advice and the word review mean something different than the word approve or the word sanction or certify. When an architect reviews documents, the architect is not certifying or sanctioning those documents. And in particular, one area that you may want to look at if you're about to enter into an AIA contract is the area of shop drawings. In the AIA documents, it is said that the sub or the contractor is supposed to provide copies of the shop drawings to the architect for review prior to installation in the field. The architect is responsible now to review these documents and send them back to the contractor. However, that process does not say that the architect is being responsible for those shop drawings. Should the drawings be in error, the responsibility would either be of the sub, but ultimately would be to the contractor. The architect in these documents is not responsible pretty much for anything. The architect is expected to review payment application. The architect is expected to make timely decisions. And number 7, in the event of a dispute, the architect is supposed to wear another hat and adjudicate disputes initially. If the adjudication cannot be made by the architect, then the claim moves forward through the documents and an alternate process is selected. So what is the contractor supposed to be responsible for in this entire situation? Well, first of all, the contractor is responsible to the contract, is responsible to codes and any laws that apply to contracts, to apply to their contracting field, including 489, including the lien laws, and including any other laws that affect them. Number 2, the contractor is responsible to verify all field details, and this is a critical requirement on the contractor. Remember, when we talked in general about contracts, one of the ways in which we could get out of a claim was by claiming that there were unanticipated site conditions. Well, if these documents clearly put the responsibility of verifying conditions in the field on the shoulder of the contractor, then the contractor is not easily going to be able to claim that there were unexpected site conditions. Number 3, the contractor is responsible for all subcontractors. Number 4, the contractor has both the responsibility and the license to act to protect the property. And if that action is in good faith, and if it costs the contractor money to protect the property, then the contractor should be reimbursed for this act of good faith. Number 5, the contractor is to provide a schedule of values. Number 6, documentation, including insurance. Number 7, a list of proposed contractors to which the owner or architect can make reasonable objection if necessary. The contractor is expected, number 8, to obey directives. Number 9, to give timely executions of the work. Number 10, to give fair valuations to work. For example, in a change order, the contractor is supposed to give fair value to requests for additional information. And finally, to promptly pay the subcontractors, which means to pay them within 3 days of having been paid. Well, then what is the role of the subcontractor in all of this? Well, the subcontractor is governed by a separate document, the 401, and specific requirements to the subcontractor, such as timelines and that sort of thing, will be found in 401. But in general, the subcontractor is stating that the sub is familiar with the documents and familiar with the site conditions. And number 2, the 401 gives the subcontractor the same obligations to the contractor that the contractor has towards the owner. That's why it's imperative, if you're going to sign one of these contracts with an owner, that in fact the contract you use with the sub is the same contract. Off to the side here we have the other document that the test focuses on, which is the 701, and this is the document that deals with bidders. And the bidders are saying that they are familiar with the documents and all field conditions. They are expected to bid exact documents, or if they're going to propose changes or exceptions, they must do so within the allowable time frame. They are expected to be fair and competitive in their bid practices, and they're expected to stick to their bid, which is often enforced by the use of a bid bond. And you'll remember that there are 2 types of bid bonds, one in which you give up the collateral that you have listed, and one in which you may do that and also wind up having to pay the difference between your price and the next lowest bid. These different relationships comprise the basic attitude of the AIA documents, and if seen in this light, you're going to have a much better idea of how the specific requirements of each document runs. One of the features of the AIA process is how claims are dealt with. And if you look on this exhibit, you will see the basic claim cycle, and time is moving from the left to the right here. The first thing that has to happen is the event must be recognized, and we have to be careful what we mean by recognize. The effective recognition is not necessarily when you or one of your personnel recognize the condition. It may be that it is the effective moment that the architect confirms the observation. So an issue might be what constitutes the real recognition of the problem, and if it came down to a question of whether it was the contractor's observation or the architect's acknowledgement, it would be the architect's acknowledgement that really set the clock ticking. But once the event is recognized, you have 21 days from, which means add, that we have until we actually file a piece of paper that would be a claim. And any such claim would be made on a change order. We would use the change order form to simply process the claim. Now what's going to happen is that within a 10-day period of time, the architect is going to review the claim, and the architect is going to be able to take any one of 5 actions that are listed in the section of the AIA document. The architect then is going to make a decision, and this decision is supposed to be fair and balanced. But it may be the case that there can be no agreement as to what a fair and balanced decision might be. And in that case, once the architect can no longer control the process and no longer is able to come to a meeting of the minds, then the AIA documents require that mediation be participated in. Now you'll notice here that mediation is mandatory, but you do not have to agree with the outcome. And so that's referred to as mandatory, non-binding mediation. In other words, mediation process is going to get everybody's cards on the table and attempt to clarify what the issues are. If it's successful, there will be a meeting of the minds and there'll be no more issue.